Glenn, explain this move to us. Is a move to delay cause for concern about the case?
No, Jonathan, I think it's thoroughly unsurprising. I don't know that all legal analysts agree to everything all the time. But I think when we all saw Judge Aileen Cannon set the trial date for August 14th, our immediate reaction was, yeah, that trial date is not going to hold. Now, we understand why she did it. The Speedy Trial Act provides that somebody is to be taken to trial within 70 days of their arraignment. So Judge Cannon, I think, appropriately set a trial date for about 63 days from the time Donald Trump was arraigned. But it was entirely unrealistic, particularly in a case that involves classified information like this, because the defense attorneys have to apply for and be granted security clearances. And the prosecutors and the Department of Justice had said, we will speed it up. We will move at light speed. But they also note that some of the defense attorneys haven't even filed the preliminary paperwork, the SF-86 National Security Questionnaire, to even get the security clearance ball rolling. I don't think that was a slap at the defense team. I just think the prosecutors were highlighting for the judge that, look, there is going to be more run-up time to this trial because of the nature of the evidence, these highly classified documents, than is otherwise, ordinarily the case in trial. So I don't think this is all that remarkable. I think we were all expecting it.
And Brad, here's what Andrew Weissman tweeted about this motion. Quote, the government SEPA motion is standard, other than it is taking out the big crayons to teach the district judge about the basics of SEPA, which she will need to master in order to handle the classified discovery issues. Is this delay as much for Cannon's benefit as anyone else's?
Yeah, no, Andrew is right. And Glenn kind of hit on it in the idea that none of us believed this trial was going to happen in August. That just wasn't plausible. But yes, this is what the government almost always does in every case that involves SEPA, the Classified Information Procedures Act, and particularly in one like with Judge Cannon, who hasn't had the experience, not just in her own, professional life before being a judge, but particularly as a judge. She hasn't presided over one of these before. She hasn't dealt with the different notifications that both the government and quite possibly Mr. Trump's team will have to make about any classified evidence that has to be introduced at trial that they intend to provide. There's going to be a fight almost certainly between the parties in what's called a Section 6 hearing before Judge Cannon in terms of what type of classified testimony and classified documentation is going to be produced at trial, how it's going to be produced at trial, whether it be redactions, whether it be substitutions or stipulations. Those are all kinds of fights that have to happen before we ever get close to trial. And that's going to easily take weeks before we even get to these guys having clearances, which they haven't even gotten to yet.
Wow. So, hey, Glenn, much like the evidence they released on Wednesday, is this a power move from Smith and his team, a way to show Trump and the judge that they ain't messing around?
I don't think it's a power move as much as it is a necessity in, SEPA trials. What I did think was really interesting, Jonathan, was that discovery letter that Jack Smith sent saying, listen, we're not even required to give you all of the witness statements or all of the grand jury transcripts. Ordinarily, prosecutors only give over the grand jury transcripts for the witnesses they intend to call at trial. But boy, Jack Smith went above and beyond and said, we're going to give you all the grand jury transcripts. So what does that mean? That means Donald Trump now knows all of the witnesses who went into the grand jury and what they testified to about his crimes, which is probably why he erupted in that post and expressly urged Congress to, quote, stop this now, which feels a little obstruction of justice-ish to me.
Oh, yeah. Yeah. Let me get you on one more thing. So do you think that, speaking of power moves, Glenn, this is a question I asked Harry Litman last night, do you think that this is Jack Smith's attempt, by giving him all of this stuff, hey, dude, here's the case against you. You might as well just, come on, think about settling. Let's make a deal.
I think it could have that effect for any other litigant other than Donald Trump. Donald Trump is not big on taking responsibility for his own misdeeds. I think the other thing Jack Smith was doing, though, was not only being fully transparent, providing more discovery, more evidence than the rules actually require him to provide. But, you know, we have seen prosecutions break bad in the past. For instance, the Senator Ted Stevens case, where the prosecutors won a conviction, but they lost the appeal because it turns out they didn't give over all of the evidence that could have been helpful to the defendant, that might have been Brady evidence. I don't think Jack Smith wants to run the risk of any of those problems, and he is going to play this straight up and then some.
So, Brad, let me read this line from the filing, and here's the quote. Defense counsel anticipate filing in opposition to this motion addressing their objections to the government's proposed dates. So, Brad, do you think they'll try to push it back even further?
Oh, absolutely. They want this delayed as much as possible. One part being simply they want it as close to the election as possible so that if this does make it to trial and if he is convicted, it'll make it so that there's no sentencing before the election. So if he can get the nomination, if he can somehow win the general election in November 2024, he can basically vitiate any sentencing that would come down because he can just pardon himself once he takes office. They have no desire to rush this. They have every desire to hit it with pretrial motions and to appeal anything they potentially lose up to the 11th Circuit and to delay this as much as they can.
And one more question for you, Brad. What are your takeaways from the new motion tonight from the special counsel about the 84 witnesses that Trump and Nauta are prohibited from speaking to?
Yeah, this is Jack Smith basically saying when we get to this trial, it's not going to be just one person verifying where this box was or one person verifying what Nauta did with these boxes or what they saw in your office. It's going to be multiple people. We're going to have confirmation upon confirmation upon confirmation. There's not going to be any issues of misinterpretation or one person's particular analysis. It's going to be a brick wall, a beautiful brick wall of evidence showing exactly how much we have to show, not only that you retained the documents, but that you obstructed efforts to get them back.
Hey, Glenn, I'm going to squeeze in one more question before we have to go. Are all the Trump trials going to run into each other? Because his Manhattan trial is coming up in early 2024.
Yeah, they might. And the prosecutors are going to have to coordinate on the scheduling front. They're going to have to prioritize. But you know what? It's maybe a good thing that the judge may end up vacating the August trial date because, you know, we all kind of suspect that Donald Trump might find himself occupied down in Georgia in August, perhaps being arraigned down there by District Attorney Fani Willis.